Hello students, welcome to One Day Law Revision Module 7 Interface of Competition Law with Other Laws. Let's quickly go through the synopsis first. Here we will cover intellectual property right and competition law, international trade and competition law, consumer law and competition law. So as per my opinion, the most important question for you will be consumer law and competition law, and second will be intellectual property right and competition law. And priority wise, you should give first priority to this A, second B, and third C. So first we will see this, second this, and third lastly we will see point number 2. So let's get started. Competition law and intellectual property right, a critical analysis. These both, competition law and intellectual property law, we will call it CL and IP. Fine. ये दो मेन एरिया है गवर्निंग द मार्केट एंड प्रमोटिंग कंज्यूमर वेलफेयर एंड ट्रांसफर ऑफ टेक्नोलॉजी. ये दोनों के बीच का जो रिलेशनशिप है ना, दैट प्लेज अ वेरी वाइटल रोल इन मेंटेनिंग द कंपटीशन एंड डायनामिक इकोनॉमिक मार्केट. दोनों में कुछ सिमिलैरिटीज भी है, दे आर कॉम्प्लीमेंट्री टू ईच अदर, बट अपोजिट भी है. दोनों के एस्पेक्ट अपोजिट भी माने जा सकते. लाइक यहाँ पे जैसे दिया, दे कैन बी लाइक फायर एंड वाटर एंड आर एंटायरली डिफरेंट. Competition law seeks to eliminate any practices that restrict trade and generally discourages monopoly. Competition law क्या बोलता है? मोनोपोली को हम डिस्करेज करेंगे, कंपटीशन को बढ़ावा देंगे, फेयर कंपटीशन को. और अपोजिटली इंटेलेक्चुअल प्रॉपर्टी लॉ क्या बोलता है कि हम इंटेलेक्चुअल प्रॉपर्टी राइट दे रहे किसी पर्सन को कि सिर्फ वही फ्रीली उस राइट को यूज़ कर पाएगा, एंड हम एक्सक्लूसिविटी मेंटेन कर रहे कि उसके पास ही वो एक्सक्लूसिवली वो राइट है. अपोजिट हो गए लाइक फायर एंड वाटर, जहाँ इंटेलेक्चुअल प्रॉपर्टी राइट एक्सक्लूसिव कंट्रोल देता है किसी इंटेलेक्चुअल एसेट पे किसी राइटफुल ओनर को. कंपटीशन लॉ क्या बोलता है कि हम मोनोपोली को इनकरेज नहीं करेंगे, हम मार्केट बैरियर्स को हटा देंगे, हम कंपटीशन को बढ़ावा देंगे अमॉन्ग वेरियस सप्लायर्स, सर्विस प्रोवाइडर्स, टेक्नोलॉजिस्ट टू एंश्योर मैक्सिमम बेनिफिट टू कंज्यूमर. अब इनके जो अपोजिट नेचर है और जो डिफरेंट गोल्स है उसके वजह से कुछ कॉन्फ्लिक्ट हो सकता है. कंपटीशन लॉ का मेन मकसद क्या है? अदर देन फेयर कंपटीशन, नेसेसिटी फॉर फ्री मार्केट जहाँ फ्री ट्रेडिंग हो, बाइंग सेलिंग, एस्पायर टू क्रिएट अ परफेक्टली कॉम्पिटिटिव ग्राउंड, परफेक्ट मार्केट, फ्री एंट्री, बेनिफिट कंज्यूमर चॉइस एक्सेट्रा. इसका काम है कि वो फ्री ट्रेड, कंज्यूमर राइट्स, इफिशिएंट रिसोर्स अलोकेशन को प्रोटेक्ट करे. और इंटेलेक्चुअल प्रॉपर्टी राइट क्या बोलता है कि हम मोनोपोली क्रिएट करेंगे. इन द सेंस देयर इज अ कॉन्ट्राडिक्शन बिटवीन द टू. सेक्शन 3 सबसेक्शन 5 ऑफ कंपटीशन लॉ टॉक्स अबाउट. सेक्शन 3 बात करता है एंटी कॉम्पिटिटिव अग्रीमेंट की, और सेक्शन 3.5 बात करता है एक्सेप्शंस की, कि किन कॉन्ट्रैक्ट को इवन इफ दे साउंड लाइक एंटी कॉम्पिटिटिव अग्रीमेंट उनको हम एंटी कॉम्पिटिटिव अग्रीमेंट नहीं मानेंगे. दिस टॉक्स अबाउट एक्सेप्शन. उसका जो क्लॉज 1 है दैट इज अबाउट IPR, दैट डील्स इन IPR. सो द सेक्शन स्पेसिफिकली एक्सक्लूड्स IPR फ्रॉम रेस्ट्रिक्टिव ट्रेड प्रैक्टिसेस एंड अटेम्प्ट्स टू रिजॉल्व सम ऑफ द कॉन्ट्राडिक्शंस. ये जो कॉन्ट्राडिक्शंस है हम उसको रिजॉल्व करने की कोशिश कर रहे हैं, क्योंकि इंटेलेक्चुअल प्रॉपर्टी राइट एक प्रोटेक्शन भी है. इट इज़ नेसेसरी एज इट इज़ अ प्री रिक्विजिट फॉर इनोवेशन. इनोवेशन के लिए ये ज़रूरी है, विच इज़ वाई मोस्ट लॉज इंक्लूडिंग कॉम्पिटिशन लॉ गिव्स अ प्रायोरिटी टू IPR प्रोटेक्शन. कॉम्पिटिशन लॉ क्या है? एक बॉडी है दैट हेल्प्स इन प्रमोटिंग द मार्केट कॉम्पिटिशन बाय रेगुलेटिंग द मार्केट. इट मॉनिटर्स एंटी कॉम्पिटिटिव कंडक्ट ऑन द पार्ट ऑफ बिजनेस एंड रेगुलेट्स द सेम. ऑब्जेक्टिव क्या है कि फेयर मार्केट प्लेस हो, फेयर कंपटीशन हो फॉर कंज्यूमर, ताकि वो अपने प्रोडक्ट्स को इजीली चूज कर सके एंड बिजनेस कैरी ऑन कर सके. अनएथिकल प्रैक्टिसेस को ये प्रोहिबिट करता है एंड इट एम्स एट गेनिंग अ लार्ज मार्केट शेयर. जिसके प्रोहिबिट करता है लार्ज मार्केट शेयर को, जिसकी वजह से स्मॉल बिजनेस को एंट्री इजीली मिल जाती है एंड दे कैन ट्राई द लक इन द मार्केट. कुछ एंटी कॉम्पिटिटिव अग्रीमेंट्स क्या है? प्रेडेटरी प्राइसिंग, प्राइस फिक्सिंग, बिड रिगिंग, डंपिंग. तो ये सब प्रैक्टिसेस को कंपटीशन लॉ प्रोहिबिट करता है. दीज प्रैक्टिसेस आर जनरली प्रोहिबिटेड बाय मोस्ट कंट्रीज एंड आर डीम्ड टू बी एंटी कॉम्पिटिटिव. ठीक है. अब आईपीआर क्या है? इंटेलेक्चुअल प्रॉपर्टी राइट. अकॉर्डिंग टू वर्ल्ड इंटेलेक्चुअल प्रॉपर्टी ऑर्गेनाइजेशन, IPR refers to creation of mind such as innovations, inventions, literary, artistic work, design, symbol, names, images that are used in commerce. ये क्रिएटिव वर्क है, completely of brain, completely of mind. तो यहाँ पे ओनर को सोल राइट मिलता है कि उसने जो क्रिएट करा है उसका बेनिफिट वो ओनर ही ले सकता है. So this right is intellectual property right. Article 27 of the Universal Declaration of Human Rights provides for the right to benefit for the protection of the moral and material interests resulting from authorship of scientific, literary और artistic productions. ये साइंस को प्रमोट करता है, टेक्नोलॉजी को प्रमोट करता है, आर्ट को करता है, एंड बेनिफिट्स इन प्रोटेक्शन ऑफ मॉरल एंड मटेरियल इंटरेस्ट रिजल्टिंग इन ऑथरशिप ऑफ साइंटिफिक, लिटररी और आर्टिस्टिक प्रोडक्शन. It is therefore necessary to protect the intellectual right. They are extremely private rights and they are classified under the following types. Copyright हो गया, trademark हो गया, design, patent, geographical indication, etc. Relationship between competition law and international trade हम ये बाद में देखेंगे. Last topic cover करते हैं consumer law and competition law. Consumer law यानी कि कंज्यूमर के इंटरेस्ट को प्रोटेक्ट करना, ये सेंट्रल एस्पेक्ट ऑफ द मॉडर्न कंपटीशन लॉ एज वेल एज इट डायरेक्टली एम्स ऑन कंज्यूमर प्रोटेक्शन लॉ. So despite being complementary in many ways, they have some different issues they are covered and employ different methods to achieve the goals. Now consumer protection rules are built upon the premises that consumers are the weaker party to transaction and should be directly protected. मतलब ये कंज्यूमर के डायरेक्ट प्रोटेक्शन की बात करता है. For these reasons, in the dealings with traders through certain consumer rights, competitive law only indirectly protects the consumer economy well-being. This directly protects, these indirectly protects. Why indirectly? Because the main aim is to promote fair trade, and here it is to only protect the consumer. So that's the main difference. This article explores the interplay between consumer protection and competition law in the Indian context with some comparison with the EU position. Relevant. After examining both the laws, consumer law as well as competition law, you will see that the main aim is that it mandates the Competition Commission of India to prevent practices that are having adverse effect on the competition. Appreciable adverse effect on competition. Then these practices are prevented. The treatment of unfair trade practice is used to demonstrate the appropriateness of this approach. Using competition as a tool bears following benefits of the consumer. So using competition law indirectly helps the consumer as it helps in lowering the prices and improving the quality. So consumer gets the benefit of that. Consumer will get various options, will get the will have to pay the lower price with a better degree of competition. Productivity of the industry will increase, employment will increase. It leads to consumer empowerment also because of promotion of factors like high degree of consumer protection, freedom of individual choice, and when you get the choice, you get the right to bargain. The consumer is in the position to bargain, and then he will get the product for a better price. He will be able to bargain properly. It also aims for open market so that the situation of shortages can be avoided. Can be called as a perfect market scenario. That's the aim, and therefore allocative efficiency may be increased. By achieving all these objectives, growth and development get accelerated and political and economic democracy gets preserved. It also produces better and wider choices. So this was again important topic. अब लास्ट है रिलेशनशिप बिटवीन कॉम्पिटिटिव लॉ एंड इंटरनेशनल ट्रेड. तो कॉम्पिटिशन लॉ का हिस्ट्री तो ऑलरेडी हमने कवर किया है. In 1969, we saw that India adopted its first competition law, that is MRTP Act, which was introduced in Parliament in 1967. फिर उसके बाद बहुत सारे amendments हुए in the MRTP Act, and then after that the Raghavan Committee, after so many amendments like 1980, 1982, 1984, 1986, 1988, ये हमने पूरा हिस्ट्री में कवर किया था. After all that, in 1991, we saw that after the liberalization, privatization, globalization concept, the liberalization procure was to eradicate those division of MRTP Act and consider able actions to seek approval from the administration before commencing any movement. In 1999, the Government of India established Raghavan Committee under the chairmanship of Mr. S.V.C. Raghavan to suggest a more updated competition law system considering the global improvement. So they were having two choices, either to alter the act which was already in the picture, or to bring the new act. So the Raghavan Committee introduced its report to government in May 2000, and then the act was brought in the parliament, and then Competition Act 2002 came into picture. In MRTP Act, various significant terms were not characterized, like maltreatment of strength, cartels, agreements, estimating on external territory, ward, etc. We have already seen the distinction between MRTP Act and Competition Act in module number 2. You can check that again, and also you can mention it here. The Raghavan Committee recommended sanctioning of another opposition law as to oppose to making further changes to the MRTP Act, because already MRTP Act has got so many amendments and so many changes. So Raghavan Committee suggested that let's make a new law. So considering the suggestion of Raghavan Committee, the MRTP Act was abolished and the new act came into force on 4th and then the act was effective from 4 September 2009. The principal objective of MRTP Act was to forbid monopolistic, prohibitive and uncalled for exchange resources, while Competition Act was sanctioned to advance competition. The focal point of MRTP Act was to limit strength in exchange. Competition Act was on additional on conferring the maltreatment of predominance by nature. Connection between global exchange and competition law was first seen in General Agreement on Tariffs and Trade, that is GATT, 1947 to change exchange laws. Its replacement by WTO was acquainted with diminish or dispose of exchange obstructions. Competition law was to a great extent outside the extent of WTO. Competition strategies were viewed as a homegrown issue. Period is gone, and today the competition law across the global incorporate a worldwide perspective. We have seen the competition law of UK, we have seen of USA, we have seen of EU, and we see that some or the other way they are in line with the Indian law. So value fixing, maltreatment of strength in the tech business, cross-boundary consolidation and market sharing arrangements among different occasions, effective spill over from one ward to another, development with respect to the decrease of restraining infrastructure, advancement and privatization of specific areas, just as fast innovative changes and the opening up of global exchange have released exceptional financial powers which thus sway across various locals merely. यहाँ एक obvious requirement है for more grounded components of worldwide participation, that is issue of local and overflow are to be settled. So here we underline that the enemy of serious practices disclosed beneath are unfavorable to worldwide exchange. Union in competition law is alluring in light of the fact that it guarantees exchanging countries are in a situation to receive the reward of exchange progression. So like nothing to be explained, it's the history and we are only discussing the principles. Typical theory question, write as it is. Try to write as it is, revise again and again, so it will be helpful, but I doubt this question will be asked in the exam. First 2 points they will surely ask. A cross-line consolidation particularly turns into a reason for concern when there is a chance of clashing choices by the opposition specialist of the at least two purviews. So we'll consider at least two purviews. A cross-line consolidation can sometimes result into distinctions. They can be different policies, which can lead to conflicts also, wherein there is a degree of contradiction between competition specialists which would promote considerable expenses being caused by the endeavors. In Western Digital versus VVT, experts in US, EU, Japan, Korea endorse the exchange subject to Western Digital's divestiture of certain creation resources for Toshiba, while Ministry of Finance Communication OM moreover required Western Digital to hold separate the VVT business with the chance to apply for a waiver following 2 years. Again, one more case law, Google versus Motorola mobility case. In that case, we observe that EU and the US, they have unvocally cleared the case. MOFCOM found that Google has a prevailing business sector position, or the way we can say dominating position, and using that predominant position, Google can downstream markets of shared versatile terminal market through Motorola mobility. Worldwide cartels, they are typically liable for exercises, for example level value fixing. Cartels मतलब क्या? Like in oligopoly we saw that major 2, 3, 4 they come together for their benefits, then they come up with policies where to cheat the customers they decide that everyone will sell the product on a particular price. Like we saw the hoarding of onions, that the onions were not bought into the market, and when the demand suddenly increased, the price was increased, and then they earned the profits at a larger scale. International Competition Network ICN was set up in 2001, and it is the solitary worldwide body which gave solely to competition law implementation and has become the pioneer in advancing global participation and competition law authorization. ICN doesn't practice any rule making capacity and just prescribes the accepted procedures and how to execute the equivalent subsequent to arriving at an agreement among its individuals. The Havana Charter, which perceived the significance of competition strategy for global exchange 1948, never becoming effective because of US not confirming the sanction, and the issue of competition strategy being dropped from the Doha round of multilateral trade negotiation in 2001, WTO individuals have neglected to arrive at an agreement or uniform competition strategy. Competition laws are generally founded on homegrown legitimate standards proposed to enlarge monetary efficiency and approval the direct offenses that could be destructive to the serious cycles. For example, tricky or exclusionary arrangements, anti-competitive consolidations, maltreatment of predominance, these all are going to affect the competition, healthy competition, fair competition. Competition law are upheld in the court and as a rule don't include the exchange arrangement strategy. They are more straightforward and hardliner. So conclusion क्या है? Competition law as well as international exchange law, they have various destinations and have had various developments too. Competition law has been restricted inside the public financial circumstances, while international exchange is on the worldwide level. It helps to loosen up administrative estimates which control and limits cross-boundary exchange. These two fields of law communication in various types of monetary circumstances and act in correlative way with each other. So these were the three topics in this module. We have covered firstly the competition law and intellectual property rights, second the consumer law and intellectual property right, and third international law and competition law. So I hope you understood. This was the last module of competition law. All the best for your exam. Thank you.